Okay, Mr. Richardson.
Thank
I
you,
hope we're on the last push, right?
Thank you, Mr. Chairman.
Objection, non-responsive.
Sustained. Mr. Winnick, SC&G didn't do any of that additional work either to finalize the changes needed to the schedule in response to that recommendation of Bechtel, did it?
That wasn't a recommendation. In the language is actually changed in the report to I think, confirm my interpretation. It says a more robust probability assessment approach would be needed before finalizing any changes to the project baseline target schedule. Would be implies to me that it's not a recommendation, whereas it said is in the slides, and slides aren't often prepared as carefully as reports. I think Bechtel again in their actual report. And just for the record, it's Exhibit 119, page 5, says would be needed. That tells me that they're saying that they would need to do a more robust analysis, namely an analysis with, at a minimum, a level 3 schedule, and one that was based on more than just commodities, bulk commodities.
Mr. Chairman, by agreement, we'll let Mr. Troutman of Bechtel clear that point up. Instead of cross-examining him about that. Moving on, you didn't analyze the consortium schedule, did you?
No.
And you didn't know if the consortium schedule at the time was fully integrated or not, did you?
Actually, I do know that. I was reminded of that because Bechtel says it was fully integrated in their report.
Bechtel says that the consortium schedule at the time was fully integrated.
Yes, sir, they do.
May I suggest that we let the report either be pointed out later or just move on? I don't doubt that he believes it. I doubt that it's in there. I think we can move on.
Move on's always a good option.
My question was, does he know? And if he's basing it on what's in the report, I think we can take that as the answer. If you're willing to do that, Mr. Winnick. No.
I'm certainly willing to say that I didn't review the schedule independently myself. Most of the information I have about the schedule I got from third parties, but in this case, I remember that Bechtel specifically pointed out that it was fully integrated, by which they meant that engineering, procurement, and construction were all addressed in the schedule. And I'm not suggesting that you wait while I leaf through this document, but...
We actually are going to get on that page in a weekly report in a minute. If you could just let me ask the next question. But if not, that's all right, too.
Yeah, go ahead and ask the next
All
one.
right, how about, did you know whether the consortium schedule was resource loaded, or even what level the consortium schedule was?
The consortium schedule was at least a level 3, and as I remember it, some part was resource loaded. And my memory fails me as to which part. And it's one of two, though. It was either the construction up to commissioning, or it was the commissioning portion, which is, goes on for a year or more. So one or the other was resource loaded, and it may have been, but my memory is just not clear enough on that point to swear which one.
And you knew the consortium schedule had constraints, artificial constraints in it, didn't you?
Had constraints. Artificial suggests that there's something unusual or unnatural about it, so I don't assent to that word. Constraints are normal, routine in project schedules, especially power project schedules.
And you haven't been here for all the testimony, but did you know that your client in 2015 had absolutely no faith in the schedules being provided by Westinghouse?
Well, you say, do I know that? I don't know what degree of faith, if any, they had in the schedules, so I can't agree to the premise of your question, and I can't help you one way or the other on the issue.
Then let's move on. The weekly reports were attached to the back of the final schedule, the final program assessment, weren't they? Did you ever get back to that part of the report and look at the weekly reports?
Sure.
All right, let's look at the one week ending August 28, 2015. Fourth bullet point down.
August 28.
While you get there, Mr. Winnick, this is just to show that they've downloaded all the schedule information they needed. And do you have any reason to doubt that?
Yeah, they told me that they weren't able to do that.
Let's look at it. Fourth bullet point down on week ending August 28, 2015.
Yep, I'm there.
You see where it says a CD of the owner's P6 integrated project schedule was received on August 19?
I do.
And you see where it downloaded that schedule and identified all the sub-projects?
Yes, I see that.
Looks like we'll have to put it on the Elmo.
No, I see that.
Okay, thank you.
But then it goes on to say that they couldn't.
Let me ask
They
the question.
couldn't download. Wait. You're creating the impression that this document says something that it doesn't say.
Well, you're creating
It says
the
the
impression we're gonna be here
WEC
tomorrow.
engineering files are missing, and the milestones integration file was not
Okay,
provided.
we need to go back to the question here and get to where he was, okay?
I just wanted to run through these 4 bullet points. The integrated project schedule didn't include all of the P6 schedule files, so we can acknowledge that. Why don't we put this on? Got the highlighting.
Yeah, that's all I was pointing out.
Yeah. And then you see it says without the milestone files, right here, the schedule calculations can't be performed. And we're going to answer that question on the next one. But the next bullet point down talks about there was as many as 60 mandatory constraints in the schedule precluding a true calculation of the critical path negative float. You see that?
I do,
And then I'm just asking if I'm reading it right. The next one shows that there appear to be minimal quantities loaded in the schedule. Quantities loaded are needed to understand the impacts on the installation and to sustain unit rates, right? That's the speed of the schedule, right?
Yeah, that was one of the handicaps that Bechtel operated under. They couldn't get those quantities, and without that, they were left to speculate a bit.
And the next one is the September 18th, 2015 weekly report, the very last line on that page. You see where Bechtel took the P6 construction file that it had downloaded with the 60 mandatory constraints, and it removed those so that you could actually have an analysis of how long it'll take to complete the schedule.
Yeah, I don't understand if they did that and they were confident that they had the full schedule, that would be an important data point to include in the report. But they don't. That suggests to me that they weren't comfortable that they had accurately identified what the schedule would say with the constraints removed.
Let's look at one more, and then we'll ask the question. There you see the problem on the first weekly report was that they didn't have the milestone file, and here
Yes.
they get it. This is September 25th, where they downloaded and reviewed the engineering and procurement P6 milestone file.
Yeah.
And are you aware that one of the conclusions of the Bechtel assessment was that the consortium schedule was so complex, so many items, and had constraints and was lacking resources and wasn't fully integrated, that in of itself was part of the problem that Bechtel found in his assessment of the project?
They never told me that orally, and I don't recall seeing that in the report.
And also in the report, it talked about how the project owners had insufficient controls and processes to even evaluate in real time the problems that were encountered in the schedule.
Oh, that's what they said, yeah.
Okay.
The owner disagreed, of course, but
In
That's
20,
what Bechtel said.
I'm sorry.
That is what Bechtel said.
Yes. In 2017, SCNG concluded the project would be completed 2 years later than the approved schedule and at a cost of at least $2.5 billion more than an approved budget. Did you know that in 2017?
Who said that?
Okay.
No,
I've moved on from that. So this is what I'm asking. In 2017, after the bankruptcy,
Sure.
SCNG concluded that the project was going to take 2 more years to complete and at least $2.5 billion more as a cost.
It's an owner-directed project, you mean, without the contractor, right? That was the assumption of the schedule of the assessment?
No, I think they just did an assessment of the schedule and the cost. I'm just asking, were you aware of it?
So this isn't working now?
No, it is. Just speak loudly.
Yes, sir. I'm sorry. I was aware that there was an assessment done. I didn't know those dollar amounts, and I don't recall those ever being told to me. But I believe that any assessment that was done knowing that Westinghouse was bankrupt, because by this time they were, and was done under the assumption that the owner would have to direct the work itself with or without Westinghouse's support.
All right, we're about to get to that.
Okay.
Were you aware that the guarantee by SCNG in its 2016 settlement agreement in this commission protected ratepayers from cost increases of the fixed price option, even if Westinghouse didn't?
Guarantee by whom?
SCNG in paragraph 12 of the 2016 settlement agreement protected the ratepayers for the fixed price option, even if Westinghouse couldn't.
I don't know anything about the document you're referencing.
Okay. And so when Westinghouse...
settlement agreement in 2016?
That's right.
I just want to confirm, I know nothing about that.
No problem. And in the... and so, you know, if that were true, SCNG would be on the hook to the ratepayers for any cost overruns, including their share of that $2.5 billion of additional costs.
Okay, so now you're asking me about the implications of a document that I don't know anything about. I have to say I have no idea what the implications of that document are.
All right, but you knew they did the estimate of completion and the estimate of cost in 2017?
I learned about that. I didn't know what the dates were or the dollar amounts. I just knew that it was done, and I understood that it was done based on the owner completing the work as more or less its own contractor.
Okay, and didn't you think that Westinghouse would reject the fixed price option and the EPC contract in bankruptcy?
Well, once the bankruptcy was filed, that was certainly my anticipation, yes.
And weren't you also, though, asked yourself to negotiate in July of 2017 with Westinghouse to get a contract for the design work to finish the project?
Yes, I was asked, and I did do that.
In fact, you spent about 3 days negotiating there, about 2.5
2 or 3 days negotiating with Westinghouse for them to support the project post-bankruptcy, with the owner directing the construction and Westinghouse providing engineering support.
Right, and so Westinghouse's bankruptcy did not end the project, did it?
Well, I think that it was ultimately concluded that arrangement wasn't going to work out very well. Westinghouse wasn't there. It's funny sitting across the table from somebody and you know they're not negotiating in order to build a project. What they were negotiating to do with their bankruptcy lawyers at the table was to package the Westinghouse entity so that they could then sell it to somebody else. And one of the assets that was going to make it attractive for that sale was this contract. So there was no, to my mind, I won't accuse them of bad faith, that's going a little too far, but they had a different agenda in mind than really supporting the project. They just wanted to package Westinghouse so that they could put it on the block and auction it off and get the maximum money from it.
Mr. Winnick, nothing prevented the disclosure of the underlying information from the schedule assessment, even if SCNG didn't think it was correct.
What do you mean nothing prevented it? My recommendation was the principal thing standing between the release of that document and its actual release.
And even if the report itself wasn't released, there was nothing preventing SCNG from disclosing that underlying information to the commission, was it?
I don't know of any. Every time you ask me about disclosing something in the commission, you're going to get the same answer. You can ask me that question as many times as you like,
Let's move on.
but you're going to get the same answer.
Ratepayers paid for the Bechtel assessment and all those reports, didn't they?
I don't know if part of the cost of the rate base includes the Bechtel assessment. How would I know that?
Ratepayers paid for your work on the assessment.
Again, I don't know what's included in the cost. I gathered that there were some pretty talented accountants who were necessary in order to identify what is eligible to go into the rate base. I haven't done that analysis. I haven't reviewed anybody's conclusion. It wouldn't surprise me, but it wouldn't surprise me if it weren't.
Yep. So if the ratepayers pay for the Bechtel assessment and they pay for your work on the assessment, then SCNG used their money to hide the assessment reports from them, didn't they?
The way I would put it is, if those two assumptions are true, they paid in order for me to protect their interest through protecting SCNG's interest in future anticipated litigation.
Thank you, Mr. Winnick.
Well, let me read to you
Thank you.
the Bechtel report. that
We're
says-
done. Mr. Guile.
Okay. I found the reference to the integrated schedule.
Mr. Chairman, I have no questions for Mr. Winnick.
Thank
Thank you.
you, Mr. Guile. Mr. Elliott.
Mr. Winnick, you were retained in 2011 to represent SCE&G and Santee Cooper.
Correct.
And as I recall, you were brought in to help those the owners negotiate with Westinghouse over some cost overruns and construction delays. Is that correct?
I would characterize it a little differently, but there were claims at the time, let's say that.
Well, and those claims were the shield building issues, the COL delay, and modules, correct?
And there was a small claim for rock. So
And
there were four.
all right. And as a consequence, you negotiated a settlement with Westinghouse over these delays and over these costs, correct?
Yeah, and I'm not going to correct you all the time, but it wasn't just Westinghouse at the time. But I think we know that it was the contractor. But yes, the answer to your question is yes.
And forgive me, I call them Westinghouse because it's shorter than.
And that's who they are now. We're the last part of the project.
Then I think, as I understand your testimony, or your experience, your testimony and your deposition, the owners kept you in their employ over time from 2011 at least through 2015. Am I correct?
That's true, intermittently, but yes.
And did you have some sort of a fee agreement or an engagement letter with the owners?
I've looked for that. I haven't found one, so I assume that there is no written agreement.
And you and I can agree that as attorneys, that the preferable way to handle that would have been to have some sort of an engagement letter.
Certainly, the managing partner reminds us of that constantly, and I normally do it. I just didn't do it in this case.
And some questions have come up, I think, just this afternoon over the terms of your engagement, the scope of your engagement. Can we agree to that?
Okay. Well, you're welcome to ask me about that.
Well, and I will. Just you were hired to give them advice on construction issues, correct?
That's correct.
You were not hired to give them advice on regulatory matters, such as proceedings before the Public Service Commission, correct?
That is correct.
And you weren't engaged to give them advice on what documents in your possession or theirs might be public documents, correct?
Right. They did not engage me for that purpose, and it would have been unwise to do that because I don't know the answer to those questions.
Okay. And so as a consequence, I think, as I understand it, you testified in your deposition that there had been other issues, large and small, that came up between 2012 and 2015 that you gave advice on, correct?
Yes, there were.
And I think you testified that those matters were sort of covered the waterfront. That's not your term, but some were small and some involved tens of millions of dollars?
And perhaps, at least in the aggregate, hundreds of millions.
All right. And in the course of your representation and given the size of this project, some of these issues you described would involve construction delays. Is that a fair statement?
There were allegations of delays and delayed claims, yes.
And perhaps some cost overruns, correct?
Yes, and the cost associated with the delay is correct.
And I think that ultimately, as you've testified this afternoon, you were advising the owners with respect to these issues that gave rise to the EPC amendment of October 27th?
Yes, I was advising them as to those issues.
And would it be fair to say that you would have ultimately recommended to the owners that they enter into the EPC agreement of October 27 of 2015?
Yes, and you can even go further and say I did in fact recommend that they do that.
And in that document, in the settlement, as I understand it, the Westinghouse bought CB&I out of the consortium. Is that a fair statement?
Without getting into the details of the transfer, that's a good summary of what happened.
And there were mutual releases executed as a part of that 2015 EPC amendment also, weren't there?
Yes.
And basically, the owners, SCE&G and Santee Cooper, released Westinghouse and CBI, correct?
From claims. It wasn't a general release. It was of specific claims and all claims known.
Up to the point, up to October 27 of 2015.
Precisely, yes.
And conversely, CBI and Westinghouse released the owners from any liability under the same terms?
Under the same terms, yes, that's correct.
And CBI was allowed to exit the consortium, but now CBI or its parent had given a guarantee to the owners, had they not?
Yes.
And I want you to tell me about that. It was a parental guarantee, as I understand it, correct?
Yes.
And who was CBI's parent?
Going from memory, I believe it was a Dutch company. I don't remember the name.
Very fine. And what were the terms of the guarantee?
As I remember it, the guarantee was limited to, in case of the termination by the contractor for default, was limited to the unpaid portion of the fixed and firm price portion of the contract.
And can you give me any more specifics? The Commission, I think, would be interested in hearing.
Well, it actually is kind of interesting the way it all played out, because the exposure of the contractor in case of default was limited under the construction contract. I've mentioned two of the four components, pricing components of the contract: firm, fixed, target price, and T&M. Target price was where the real exposure was, but there was no relief to the owner in case of termination of the contractor for the target price, with respect to the target price component. And that's where the big risk was. The only relief to the owner was in connection with the fixed and the firm prices, and those were for equipment, and much of that equipment was pre-purchased, and so the risk there was small. So the chance of getting any relief through these guarantees was really limited until we exercised the fixed price option, because then the entire contract becomes subject to the fixed price, and therefore the entire contract becomes subject to the provision that says that the owner can recover for any excess cost under the fixed price. Now that's a little complicated. It's hard to keep in your head, but if you want to ask me questions about that, I'm happy to tell you.
Yeah, I want to ask you this, if I may, and that is that, so if CB&I had stayed in and had been in under the fixed price contract, their guarantee would have been worth more to the owners. Is that what you testified
Well,
to?
and what happened is that we had, in lieu of the guarantee of the CB&I owner, we had the guarantee of the Toshiba, which was Westinghouse's owner. And so the mechanism, the increase that I just explained, did in fact happen. It just became a liability of Toshiba instead of a liability of the CB&I parent.
And if I'm correct, CB&I has never declared bankruptcy, whereas Westinghouse has. Isn't that true?
That's true. CB&I is still a going concern.
Now, as I understand it, the October 27 amendment of the EPC established completion dates of 2019 and 2020.
Yes. Is it August?
Please help me.
It's 2019 and 2020. I mean, we can leave it at that if you like. August 31, 2019 for Unit 2 and August 31, 2020 for Unit 3, and that's in Exhibit 114, page 3, paragraph 6.
Now, as I understand it, you very quickly after learning what you needed to learn about the Bechtel report, dismissed their analysis on the schedule. Isn't that correct?
That is true.
And wouldn't it be true to say, Mr. Winnick, that when you heard their analysis on that October 22 telephone call, you realized that in your mind, Bechtel did not say anything that would dissuade you from agreeing to the 2019-2020 schedule that SCE&G and the Santee Cooper agreed to in the October 27, 2015 EPC amendment. Isn't that
That's right. They didn't say anything that I took to heart that caused me to change my recommendation concerning that October amendment.
All right, sir. And then your preference was to stick with the 2019-2020 Westinghouse schedule analysis, notwithstanding the fact that your entire your representation of the owners on this matter involved construction delays from 2011 to 2015, correct?
Well, notwithstanding anything, I was making that recommendation.
And in fact, you know, because I know you're thorough and I know your work, you know that even at the outset in 2008, Westinghouse was not able to give SCE&G and Santee Cooper a reliable schedule. You know that, don't you, sir?
There were a lot of unknowns. I don't know enough details about 2008 to be able to give useful testimony about that. I don't know what was reliable and what wasn't at that time. I know that there were at least 2 adjustments, one in July of 2012 and one in connection with the October amendment of 2015.
Very fine, thank you. And you understand that notwithstanding your efforts to eliminate any reference to the schedule in the Bechtel report, that the Bechtel report in the executive summary does provide the consortium lacks the project management integration needed for a successful project outcome. You recall that?
I do.
All right. And so after you entered into this, E&G entered into this agreement, I think Fluor came in. Is that correct?
That's correct.
And then I think this 2015 EPC amendment lacked provisions for construction milestones going forward, say beginning about January of 2016. Isn't that correct?
That's right. So the agreement took effect, as I remember it, end of December 2015. And then the question is, how do you pay the contractor after that? Because under either approach, a fixed price of the 4 areas, there was no mechanism for payment.
So you recommended an agreement to SC&G and the owners that did not provide for a mechanism of payment to the contractor?
No. What I'm saying is that there was the existing provisions were not did not cover the new deal, because under the non-fixed price approach, for lack of a better word, there was $250 million added to the construction price. Under the fixed price approach, there was a different adjustment made. So the question is, how would you pay the contractor until you had a new mechanism that was consistent with the revised contract price? The new mechanism became known as the construction milestone payment schedule. And until that was in place, there were agreed monthly payments that would be made to the contractor, because otherwise contractors don't work for free. And that wouldn't have been good for the contractor or for the project.
And we can agree that the milestones are actually part of the schedule, aren't they?
Well, that's not quite right. The construction milestone payment schedule used activities that were in the schedule, but it wasn't literally part of the schedule.
But we call it a construction milestone schedule, correct?
Well, payment schedule.
All right.
So it's not a schedule of work. It doesn't tell you when activities start, when they end. It just identifies an activity by number and date, and then tells how much money is going to be paid when that activity is completed.
And so the 2015 EPC amendment did not provide for payment terms according to a milestone schedule. Is that correct?
Okay, I'm sorry. I answered you before you finished your question, and having heard the rest of your answer, you're right. There was not a provision in the October amendment for payment of the new contract price using a construction milestone payment schedule. There was an agreement to develop such a schedule consistent with the revised contract price, an agreement to make interim payments until that new negotiated construction milestone payment schedule was in place.
And so as I understand it, then you have to help me here. SCE&G itself began in January 2016 paying $100 million a month to Westinghouse?
No, the agreement was that the owner would pay $100 million a month during that interim period, and that any of those payments would be credited against the contract price. So it wasn't as though these were free payments in addition to the contract price.
So, but you corrected me in that to say that both SCE&G and Santee Cooper were paying $100 million a month.
Yes, all of these obligations were owner
You're
obligations.
speaking the total.
Yeah, no, I assume it was split 55-45 according to the ownership interest.
And so as I understand your deposition testimony, as a result of this 2015 EPC amendment, SCE&G and Santee Cooper began paying $100 million a month to Westinghouse without regard to a milestone schedule or even invoices?
That's right.
And so as I understand your testimony, this EPC agreement obligated SCE&G and Santee Cooper to pay perhaps as many as $500 million before Westinghouse was obligated to provide a milestone construction schedule?
Well, understand that it wasn't Westinghouse's obligation to provide one. It was the joint obligation of the parties to negotiate one. And there was an effort to negotiate that, and that went back and forth. But the central premise is correct, that during that negotiating period, in the absence of any other mechanism, the agreed price was $100 million.
So the EPC amendment put the burden on SCE&G and the Santee Cooper to come up with a milestone construction schedule while they're paying $100 million a month.
Yes, and that may have been adequate or may have been deficient relative to what the contractor was spending.
And I think that did the owners not end up paying about $800 million before there was a milestone construction schedule agreed upon?
well, your number from memory is correct, except the milestone schedule was never agreed upon. We had to go to the dispute review board, and the dispute review board then established the construction milestone payment schedule, and the amendment contemplates that might happen, and that there might be 2 additional $100 million payments while the DRB process was going forward, and that did take place. But again, all of those payments, by this time the fixed price option had been exercised, and all of those payments then were credited against the fixed price.
All right, and so the SC&G agreed to commit its ratepayers to pay as much as its 55% share of $800 million before Westinghouse finally came to the table and provided a schedule. Is that your testimony?
No, they came to the table almost immediately. The parties began negotiating certainly by February, perhaps as early as January, on the terms of that schedule. So it wasn't that anybody was refusing to come to the table. It's just that people had different views. The contractor wanted to pay more sooner, and the owner wanted to pay less later.
Point well taken. And so Westinghouse had to be made through a form of mediation or arbitration to provide a schedule. Isn't that true?
Yeah, because what the amendment provided was basically an agreement to agree, which lawyers hate, because you can't enforce it. So the parties agreed to agree. They ended up not agreeing, but that was contemplated as well. We went to the DRB, and the DRB resolved it.
So the bottom line would be, if these plants had been constructed, that the ratepayers would have been stuck with about $500 million worth of payments to Westinghouse without a schedule. Correct?
No. I thought I said that a couple of times. That the fixed price amendment was exercised. Every single dollar of those multiple $100 million payments were credited against that amount. So had the project been completed, the fixed price would have remained the fixed price. Those several payments of $100 million would have been credited as a payment by the owner of a portion of the fixed price.
May I have Mr. Elmo, please, just for a moment? And now, you recall testifying with Mr. Balser about the agreement regarding owner's project assessment. That would be hearing exhibit 111. Do you recall that? I don't know where. I lost track in your tabs.
Yeah, I've got
Got to
it.
get behind that microphone, Mr. Ellie.
That's the agreement. Yes, I have that, sir.
I'm not getting any.
It all cuts off at 4:30.
Regrettably, Mr. Chairman, I did not cut off at 4:30.
I know, I kind of have.
Yeah. All right, I'll do it.
I didn't know that really happened.
Thank you. Just for reference, I'll point out this is the document. It's hearing exhibit 111, agreement regarding owner's project assessment. And I think my witness is there. Let me draw your attention, if I may, Mr. Winnick, to paragraph 6 at the bottom of page 2.
Yes, sir, I'm there.
Now, this is the exhibit that requires that the Bechtel reports be maintained confidentially, I think, isn't it?
This is one of the documents that bears on that issue. There are others, but this is certainly one of the documents. This particular document is an agreement between the owner and the contractors, and so it's a commitment by the owner as to the use to which the Bechtel report will be put.
Excellent. Thank you. And I draw your attention to paragraph 6 at the bottom of page 2, and I'll read this and just confirm for me that I read it correctly. In the event owner or Bechtel is required by law to disclose information arising out of or in connection with this agreement, such party shall immediately notify the contractor and shall take all available steps, including cooperating with the contractor, to prevent or minimize the disclosure. Do you see that? Did I read that correctly?
You did, yes.
And so this document contemplated that there might be circumstances where disclosure of the Bechtel report was required. Is that a fair statement?
Most most non-disclosure agreements do contemplate that and address that contingency. I'm sure you're familiar with provisions like this, which are standard boilerplate in non-disclosure agreements.
But we can agree occasionally that boilerplate language comes in handy, can't we?
Oh, no, there's no question. And you try to contemplate all possibilities, no matter how remote, in a document like this, and that's what that is.
Now, I think that you testified that that a Mr. Bynum was counsel for SCE&G, whom you dealt with.
Yes, that's Al Bynum.
And he, as far as you knew, he's a South Carolina lawyer, licensed to practice in South Carolina, and appeared to you knowledgeable of South Carolina law.
All those things are true, yes.
And you testified that you were the construction lawyer, but you were not the regulatory lawyer. Is that correct?
That's true.
And isn't it true, and you practice in Georgia?
I practice actually all over the country and outside the country, but I'm a member of the Georgia Bar.
And not the South Carolina Bar.
That's true, too.
To my point. And so you are entitled, are you not, to rely on local counsel for a thorough knowledge of the local laws pertaining to the matters in which you are involved?
I'm not sure I'd use the word entitled, but typically I would rely on a local lawyer that I trusted when he gave an opinion on local laws.
And you trusted Mr. Bynum.
I did.
And so your testimony is that your concern about avoiding disclosure of the Bechtel report pertained only to the federal litigation. Isn't that correct?
That's correct. And I understand that the EPC agreement is governed by New York law. You do understand that, do you not?
Yes, but
okay.
I didn't quite understand your point. Is your point really to be even more clear to testify that it's governed by federal rules of civil procedure and the substantive law of New York?
New York, yes.
Okay, good. Neither of which have anything to do with the disclosure of the Bechtel report to this commission, do they?
That's certainly my view.
And so if Mr. Bynum or the legal staff at SCE&G were relying on your work to protect against disclosure of the Bechtel report for the purposes of the federal litigation, the federal rules of civil procedure, and the substantive law of New York, he would be misplacing his reliance on your advice and counsel, wouldn't he?
I don't know, and I've never known and haven't attempted to learn whether the privilege that obtains guards the disclosure of expert reports in any other form other than the anticipated litigation of the opposing party. So I know what privilege would obtain in the Southern District of New York against Westinghouse. I have no idea if that privilege applies in any other context. Perhaps Mr. Bynum determined that it did. Perhaps he didn't look at the question. I have no idea.
Did you have the conversation with Mr. Bynum?
No.
You never asked?
No.
I
would be the wrong person to ask.
And but it's your testimony, I think, that at no time did you enter into an agreement with South Carolina Electric and Gas and or Santee Cooper to prevent the disclosure of the Bechtel report to the South Carolina Public Service Commission.
No,
Is that your testimony?
There was no agreement. There was no discussion. There was no tacit head nod or wink wink. That just never came up.
And so, I repeat, if SCE&G is relying on your advice and counsel in this federal lawsuit, as their excuse for hiding the Bechtel report from this commission, they are mistaken, are they not?
Well, see, that's what I don't know, and that's where I'm not willing to go. You're asking me to render a legal opinion about whether protection, which is clearly afforded under the federal rules, also applies in any other forum, and in particular to this forum. I don't know the answer to that, and I'm not going to offer an opinion on something that I haven't researched and don't feel competent to address.
And you don't feel confident that SC&G would be successful in raising your position as a defense to disclosure?
I'm completely agnostic on this question. You're really asking me the same question in another way. They may well be right, but I'm not going to tell you they're right. And I'm not going to tell you that they're wrong. I just don't know if that is a legitimate ground or not. I think other people have probably looked at that question, and if they haven't offered that opinion yet, they will in the future. But I don't know.
I think that's a fair answer. Thank you very much.
Thank you.
Thank you. Any other cross? Commissioners? Commissioner Elam. I tried to cut it off.
Oh, okay. Just my imagination. Good afternoon. Early in your testimony, you said that you've had these, this has been your field of law for a long time, and you were typically representing contractors against owners. Was that right?
Both those things are true, yes.
Okay. Did you change to owners, or do you now go back and forth between contractors and owners?
I represent owners when I'm contacted by owners. I will say that I think that my representation of contractors gives me special insight when I do have occasion to represent owners, because I have a better idea of what contractors are up to.
Do you have a client in the Vogel matter in Georgia?
I do not.
Okay. You also early on in your testimony said that it was typical years ago that an owner would hire its own engineer, correct?
That's true, and it still happens. It's just not as common.
Do you think that's a wise idea?
I think that the EPC arrangement, what I refer to as a turnkey arrangement, is a good idea for an owner because it does have the advantage of providing a single point of responsibility.
Has what's happened in this case changed your mind about that at all?
Well, no, because as I unpack that question, then the question becomes, well, okay, let's say you had a separate engineer and you had a separate contractor and maybe a separate procurement set of folks. If your contractor went bankrupt, you'd still be in the drink.
I'm just trying to sort through notes. You said when SC&G came to you about Bechtel that you thought that was fine, but Bechtel would not have been your choice of who to hire for that project.
That's right.
Why?
There are firms that specialize in what we can call forensic engineering, and forensic in front of any of those words just means legal related, and those firms are better set up to evaluate performance, including evaluating schedules. And I would have gone with one of those. And that's what I had in mind when I recommended bringing in somebody in 2014. But as I wrote in my May email, if they want to bring in Bechtel, that's fine. I assumed that Bechtel was conversant with the role that they had signed up for. I'm less certain of that now, but I felt comfortable then.
Okay, and I think you said Bechtel, you didn't really know Bechtel for doing that kind of an assessment.
Oh, that's absolutely true. Bechtel's been around forever and done some fabulous projects, but I don't think they've done any new construction for a long time. And but the main point is that I didn't know them as a consultant of the type that I was used to dealing with.
So putting yourself for purposes of this question, in Westinghouse's shoes, and Bechtel shows up on your site, what are you supposed to think's going on?
You're inviting speculation, so I'll speculate. I would guess that they thought that Bechtel wanted a piece of the pie. Now, just which piece might have been difficult to know. But when I say piece of the pie, I mean that Bechtel wanted to be engaged.
Could they have also thought that Bechtel really was there in anticipation of litigation?
Specifically, the fact that it was Bechtel, I think that made them nervous. And the fact that we identify them as a non-testifying expert engaged in anticipation of litigation, there's a reference in that non-disclosure agreement specifically to the rules of procedure that talks about non-testifying expert. They would have had their lawyers, who I know, look at that, and they said they're hiring them in anticipation of litigation, but
they would have believed the opposite of what it said.
No, they would believe that, but they might also believe that they would believe that they were hired in anticipation of litigation, but they might also believe that Bechtel had a private agenda, and that agenda was to get involved with the project, either as the owner, engineer, or in some larger role.
And they may not be as cooperative as if it was someone else.
I think there's some reason to believe that.
You testified, you were discussing with Mr. Richardson about the October 7, 2015 Bechtel briefing, that you didn't think that the report was important to the project. Is that correct?
By the time that they were prepared to give that briefing, yes, that's true. I didn't expect them to provide anything that was useful because the project, that was a key turning point in the project. So many things were changing, and Bechtel had an inkling of some of that. They mentioned that in their reports, that things are changing, but they wrote the report as though they weren't. I mean, one example, they wrote the report talking about how a real problem was the relationship between CB&I and Westinghouse, that needed to be worked out. Well, whoever wrote that paragraph and left it in wasn't talking to the person who wrote the paragraph about the change in the relationship. They were just, because they didn't update the report, is what I'm saying. They made recommendations, even knowing that those recommendations were obsolete.
Did they also, I believe you also testified, I don't know if it was Bechtel or you, didn't really consider CB&I to be a nuclear contractor?
I didn't. My understanding of their history, by the way, CB&I used to stand for Chicago Bridge and Iron, but they're not based in Chicago. They don't build bridges, and they don't use iron for any of their construction. Details, right. Sorry for the digression. They build tanks. They will act as vendors on nuclear projects, but if they're going to be the principal contractor, they're going to be building something else. Liquid natural gas is one of their big areas of construction. That's what, at certain years, my understanding is that's the majority of what they do. They're not really nuclear contractors.
If the issues in the Bechtel report were mooted by the 2015 agreement, why would you keep advising that the report be kept confidential?
Because there were a lot of issues in the report. The section that I mentioned about the conflict between CB&I and Westinghouse, that was mooted. The section that referenced unfavorable contract terms that had bad incentives for the contractor, that was mooted. But other things were not mooted. The section concerning inventory was not mooted. And the section concerning schedule, my objection to that was not that it was mooted, but that it was seriously flawed in my judgment. Now, again...
Was Was it seriously flawed simply because of how far in the future it was projecting completion dates?
I would have been open to being persuaded that that was an accurate assessment had they used a methodology and that I trusted, and had they had access to information, and had they had sufficient time and a sufficient budget to perform the work. If they had done all those things and come in with the level 3 schedule and demonstrated that it really couldn't be finished on the dates that Westinghouse was signing up for, that would be a completely different situation.
Did you tell your client up front when they were retaining Bechtel that there wasn't enough money or time to do an adequate job?
I didn't. I didn't. That was already a package presented to me,
So it was worked out before it ever got to you.
It was both the time frame, the number of people, and the budget, and I was hoping to get something that was useful.
Okay. In 2016, after the fixed price contract was signed, I believe you testified that neither you nor SC&G believed that Westinghouse cost elements were realistic. Is that right?
I'm not certain what you're referring to. I will say that we disagreed with their proposed construction milestone payment schedule.
No, I'm talking about once the cap was put on, the
Right.
fixed cost, that neither you nor SC&G believed that Westinghouse could actually deliver.
No, we
at
believe.
that cost.
Well, we believed that they would stay on the contract and finish the job and accept that money. Whether they could do it profitably or not was another issue. And we did a number of analyses in the fall of 2015, looking at different projections of costs, because we didn't want to sign up for the fixed price option if it was going to end up costing us more than the original approach. So we hoped that it would cost us less.
Okay.
I'm sorry.
Who did those studies?
There were people at SCE&G that did the sensitivity studies, and they were accountant types. And forgive me, but I don't know. They were mainly delivered to me at my request. That had sensitivity studies, and I prepared a series of graphs analyzing best case, worst case, most likely case financially under the old regime of 4 components versus under the fixed price option, and that was all analyzed before we even entered into the October amendment.
Okay. Who at SCANA was in there? Was that Miss Carlette Walker, or Mr. Ken Brown, or someone else?
I'm fairly certain that Ms. Walker was not involved with that, but that there were other people involved. I'm not sure she was still employed at that time, but I'm straining to remember that my principal contacts, it would have been people at what we called NND, New Nuclear Development, out in Jenkinsville.
Are those sensitivity studies things that have been provided to parties in discovery?
I'm not sure what's all been provided. I had no role in reviewing that, except my own emails.
The separate part of the last part of the Bechtel report, the schedule assessment, when was that prepared?
The separate assessment was prepared on, so far as I know, at or near the time of the date indicated on the document, which was February 2016.
That broke up the final report into 2 parts?
Yes. I can give you that date. It's February 5th, 2016.
And was it provided to the client on that date?
No.
When did Santee Cooper, as one of the clients, get a copy of that schedule assessment?
Never.
When did SC&G get it? Never.
Well, when I say never, I mean never until after the project was over. And
when did that part of the report see the light of day?
I don't know the details of that.
You didn't provide it?
I know that parties went directly to to Bechtel to get it. And did I provide it first or Bechtel provided first? I'm just not sure. But it would have been relatively recently.
The parties went directly to Bechtel.
No, not parties in this proceeding went to Bechtel, and then that report then got disseminated among everybody through the discovery process.
So you never provided that?
I believe that I did. I believe that I provided it to the attorneys for SCANA, but it would have been, as in the overall scheme of things, given that I first became involved in 2011, it was relatively recently. The precise date I would guess, I'm guessing, was sometime in late 2017, early 2018.
But senior management of SCANA knew what was in that portion of the report. You had briefed them.
They knew what was in that portion of the report from the October presentation, the oral presentation that Bechtel gave. The write-up that was done was simply a fuller presentation with a few more charts of the opinion given in that oral presentation.
Did Santee Cooper or SC&G ever share with you a report the Santee Cooper commissioned from a gentleman named Axelrod?
I'm not aware of that report. I'm not aware of Mr. Axelrod's role, what he did, or any of his conclusions.
That's all I have, Mr. Chairman. Thank you.
Commissioners, other questions? Commissioner Whitfield.
Thank you, Mr. Chairman. Mr. Winnick, just got a few questions for you here. You've said, I think, talking with Mr. Richardson and again more recently with Mr. Elliott, that your involvement goes back to 2011. Is that correct?
That's correct.
You did some things from 2011 to 2013, 4 problems, one of them being the Shield building and some other problems. That's correct also, right?
That's correct, except the time period really extended on and off until, I guess, 2016.
Okay, and you, I don't know if you were in the room or not, but a ledger was put up earlier in the case of some payments made, a ledger from SCANA's accounts payable ledger that showed some payments made to Bechtel way back as early as 2011 to 2013, that time frame period. Are you aware of that?
No, I don't know what Bechtel did. It seems to me that I may have heard that they were involved in the original licensing, but the time...
Some of the notations said engineering and licensing and that type services. I think maybe even environmental too. I can't put up on the screen. It was kind of small.
Okay, but that's something I learned recently.
So that's nothing that you didn't have any involvement with directing them way back then to use Bechtel.
That's correct. I had no involvement. Okay. I wasn't aware of it until relatively recently.
Okay, and you've said, of course, umpteen times today, you're not an engineer and you're an attorney, and certainly you don't hold yourself out as a finance expert either, right?
That's true.
But you also said that never, might be getting your exact words wrong, but never in your wildest dreams did you think Toshiba or Westinghouse would go bankrupt or would go out of business, or either one, the parent or Westinghouse.
I didn't say that, use those words, but I'll adopt those words. That was exactly my view.
Well, it's fair to say that you said you were shocked that Westinghouse filed.
And I would say in my wildest dreams I didn't imagine that these two companies that had been around for my entire life were going to have these financial problems, and one of them would go bankrupt.
It was also put up on the screen, I think, by Mr. Richardson earlier today, an email exchange possibly between you and an email from Ms. Walker about you acknowledging you had given some advice related to the BLRA, Baseload Review Act.
Yeah, and without talking about exactly what I said, what I was advising people on in that time frame was on the precise contours of the October agreement. Again, people at SCANA and Santee Cooper looked to me as the authority on that agreement. So anytime they had to write something carefully that represented the content of that agreement. They would ask me to look it over, and I would often make minor changes. There were other areas of the project that I didn't have commanding knowledge of, but that agreement I did know, and so I would look that over because of SC&G's desire that what they were telling this commission about that agreement was as accurate as possible.
Well, since you have obviously had some other casual counsel, if you will, in other matters, there's two more I want to ask you about real quickly. Back to the Toshiba Westinghouse, the bankruptcy of Westinghouse and the financial health of those two companies. Did you ever counsel them about the financial health, or did you think it was prudent for the company to dive into deeper the financial health of Westinghouse and Toshiba? Or did you ever counsel them on that matter?
Okay, did I ever counsel them? There was a time when I was requested to retain bankruptcy counsel, and so I did a search and located bankruptcy.
Specifically for Westinghouse?
Specifically for the owners to advise them on what might happen.
If Westinghouse
Yes,
went
but
bankrupt.
this was either late 2016 or early 2017.
What was the result of what did you do in that regard? I mean, specifically, did you find a bankruptcy specialist attorney for them? What did you do?
I did. Westinghouse was based in Pittsburgh, Cranberry Township, just north of Pittsburgh, historically a Pittsburgh company. So I thought it was likely that they would file in Pittsburgh. As it happened, they filed in New York. But so I reached out to lawyers that I knew who practiced construction law at the highest level to recommend local bankruptcy lawyers. They did recommend several. I spoke to several, recommended one to the owners, and the owners then retained that person.
So they actually retained that person. How far in advance of Westinghouse filing bankruptcy was that?
Well, I believe the bankruptcy was in March of 2017.
Correct.
So it would have been, as I say, in late 2016 or early 2017. And that attorney that I recommended did, in fact, deal with the bankruptcy. I don't know if he formally entered an appearance. I think he probably did on behalf of the owners, and he represented the owners in that proceeding.
There were some media reports in late December, I think of 2016, very late December, tail end of the year maybe, the last couple of days, that speculated on Westinghouse and Toshiba's financial condition. Is that along about the time you...
That's within, I would say, within a couple of weeks, plus or minus.
So it was within 90 days of probably
Certainly.
when they actually filed bankruptcy.
That's my recollection.
Last question along those lines of your counsel of them in BLRA matters. One of the conditions or promises, claims, if you will, of the 2016 fixed price option case was that the owners would finish the project with Fluor as construction manager, with or without Westinghouse. Did you counsel them to make that type claim or promise?
No, and I'm learning of it for the first time right now.
This is the first time you've heard of that?
Yes.
That's all I have, Mr. Chairman.
Thank you. Commissioners, other questions? Commissioner Williams.
A few questions. Sir, did I understand you correctly when you said that you advised SCENG and Santee Cooper on the Baseflow Review Act?
No, but I understand why you were asking the question. There was a document put up that was partially redacted, and it was an email by Carlette Walker saying that she asked me about some sort of disclosure under the BLRA, and then there was a redaction. Because there was a redaction, I know that my client has asserted an attorney-client privilege as to what I said. Frankly, I don't remember what I said anyhow. But I know the subject matter on which I gave opinions in that time frame. That was the first week of November of 2015, and the advice that I was giving at that time in connection with a disclosure to this commission was limited to the most accurate way to describe the October 2015 amendment. there are a lot of parts and pieces to that amendment. It's a complicated document. It goes on for pages, but it's not just the length. It's the number of mechanisms and how they all interface with the existing contract. And my owner clients looked to me to be the authority on that. I participated in the drafting of it. I kept track of it. I understood how it interfaced with the original contract. So that was the extent of my advice. And it wasn't really advice on should this be in or that be in. It was something that they were already had drafted, presented to me, and I edited it to ensure that it was as accurate as I could make it.
Thank you, sir. Now, is that a yes or a no? Did someone reach out to you from SCENG or Santee Cooper and say, hey, could you help me with the Baseload Review Act?
No,
Thank
that
you.
wasn't the way it was phrased.
All right. Now, you understand why we're here, right?
I understand in general terms why you're here, but I haven't studied the docket. I haven't studied all of the contentions. I don't know all the issues in front of you. And that was intentional, but partly because, frankly, I've got other things I need to do, but also because I didn't want my testimony to be influenced consciously or unconsciously by what I knew of the issues in this case. I wanted to give it to you unvarnished.
Understood.
What I remember.
I appreciate that. And I understand that you were hired in anticipation for litigation in the Southern District of New York.
That's one of the reasons.
One of the reasons, right. But we're here in the great state of South Carolina to determine the prudency of your client, SCENG's decision to abandon this nuclear project.
I understand that's one of the issues.
That's one of the issues, that's right. And do you understand that there are billions of dollars that could potentially be on the backs of South Carolina ratepayers?
I understand that that's an implication of that issue, yes.
And what we're trying to figure out is who knew what when. You understand that, right?
That's right, and I've tried to tell you what I knew at these various stages.
Okay. So there's a part in your testimony where you got a little emotional, and I understand why.
I didn't think I'd do that, and I apologize.
It's okay.
For that.
It's okay. Because there's been a lot of emotion demonstrated throughout this process.
As you age, you get more emotional. At least that's been my experience.
Understood. But there was a witness by the name of Gary Jones who testified before this commission. Did you get a chance to review his testimony?
I didn't review the whole testimony. There were certain things that were pointed out to me during my direct by Mr. Balzer, and that was really all I read of him.
Understood. He read his summary into the record, and he essentially said that he felt misled, deceived. He felt that there was a misrepresentation of material facts by SCENG, and particularly he was referencing the Bechtel report. Mm-hmm. Do you have that understanding? Maybe not from him, but just generally speaking, there's an allegation that there's some miscommunication or deception by your client, SCENG. Do you understand that?
That's right, and no one's asked me why I'm here today. I'm here today because I did understand that, and I felt that I knew what happened, and I wanted this commission to have the benefit of what I saw and what I knew.
Okay. Or what happened as it relates to the fact that this commission didn't know anything about the Bechtel report until it was arguably too late? That's an allegation that ORS didn't know anything about the Bechtel report, arguably, according to them, until it was too late, and that they felt deceived, if you will. How did that happen? Based on all the reports that you said that you were aware of and what Bechtel was doing, and I know there are certain privileges and protections available to your clients, and no one's asking you to break those, and we are well aware of all those privileges and protections, but considering the stakes for this new nuclear development project, billions of dollars, we're just trying to figure out why didn't ORS or why didn't the commission know what was going on?
Right, and that's one, what you were told or weren't told is one area where I cannot help you, because that was never something I discussed. And I'm not unable to tell you because of a privilege. I'm unable to tell you because I wasn't involved in that issue. The issue that concerned me was the allegation by Mr. Jones and others that the assertion of a privilege was a sham, or even worse, that some lawyer was sort of retained for the sole purpose or the primary purpose of shielding that document and claiming a privilege so it wasn't provided to you. That didn't happen. I was involved during all the periods that I've talked about. My decisions about privilege and how to handle that engagement were made long before the document came out. Whether or not there was an obligation to disclose that to you folks, whether that was discussed, whether it was rejected or considered and tabled, I have no idea. I was not part of those discussions. I'm here to help as much as I can on the issues I know about, but I also want you to be very clear that there are certain things I just don't know.
Understood. And I guess it's fair to say that if there was a decision made not to disclose this information to the ORS or to the commission, you had nothing to do with it.
That is fair to say.
Thank you, sir.
Thank you.
Commissioner Irvin.
Thank you, Mr. Chairman. I believe you testified earlier in your direct that there hasn't been a new nuclear plant built since approximately 1979.
Well, built, it hasn't been licensed. As I understand it, yeah, since 3 Mile Island, that they would issue no new permits no new licenses until Vogel and BC Summer.
And of the 253 nuclear power reactors originally ordered in the United States from 1953 to 2008, 48% of those were canceled. Does that sound about right?
That wouldn't surprise me, but I don't know that number. 11
were prematurely shut down. 14% were at least 1 year or more outage. I guess my point is this, knowing that this was a brand new technology in dealing with the AP 1000, and knowing that the company was having problems with these modules when you got involved early on.
Yes.
And that they were having problems with scheduling, and they were having problems with constructability reviews that weren't being performed, and difficulties with contractors. Did it occur to you to perhaps let your clients know, the owners know, that it might be prudent to cancel the project?
I never made that recommendation, and it never crossed my mind during the relevant periods. And I would say that it may seem like a small accomplishment to put in place that amendment that we did in October, but I thought that made a huge difference in adjusting the risk. Yeah, I thought that the October amendment, October 2015 amendment, made a huge adjustment in the risk. I think that the owner took on enormous risk under the original EPC contract, but I think that was a lot of that was addressed. Now, obviously, we're still here, but it wasn't. We're here. I keep saying this. We're here because of the bankruptcy.
Well, and I beg to differ with you on that, because here's what happened. When you went to a fixed price contract, you essentially put the rope around the neck of Westinghouse.
That's not the way we looked at it.
And when they went to a fixed contract, there was no way they could build it. You knew that because you knew they were way behind schedule and already over budget. And you also testified earlier that you anticipated that they could never finish the contract for that price. They were going to lose money on it. You knew that.
Well, what I knew was that Westinghouse thought that the fixed price was $500 million more than they needed to finish the project. That's on the one side of the ledger. What I also knew is that we did sensitivity analyses that indicated that the fixed price option would be advantageous to the owner.
And yet you let them go ahead and put the noose around the neck And it was just a matter of time before they had to declare bankruptcy because they were then in over their heads, and there was no possible way that Toshiba was going to let them lose that much money. Isn't that really what happened?
I understand that's your opinion. You've been clear about that, but you're asking me for my opinion, so let me give it. My opinion is that if Toshiba had not had the problems with another division, that they would not have let Westinghouse go bankrupt. That's point one. Point two, I believe that Westinghouse would have done everything possible to finish the job, as Jeff Benjamin swore in his testimony before the DRB, and that the contractor was not able to perform and didn't have the backstop of Toshiba that he had previously because of things completely unrelated to this job or the nuclear industry.
And Forbes magazine said in February the 11th of 1985, and I quote, "The failure of the United States nuclear power program ranks as the largest managerial disaster in business history, a disaster on a monumental scale. Only the blind or the biased can now think that the money has been spent well. It's a defeat for the U.S. customer and for the competitiveness of the U.S. industry, for utilities that undertook the program, and for the private enterprise system that made it possible," end quote.
Right. And I think we can do as good or a better job than the French do or the Germans do or the Finns do, all of whom get a substantial percentage of power from nuclear power. So I never, but we're not arguing or
right. It just seemed to me that
issues.
Having been on board, you were on board in 2011 on this
Yes, sir.
project, and you saw how it was on a slippery slope even then. And long before you negotiated that fixed price contract, you knew the project was in serious trouble. It was in serious trouble.
My belief before we negotiated the October amendment was that project was definitely headed for litigation. The other, Vogel was in litigation, and I thought we were headed the same way. CB&I was not performing. CB&I was at loggerheads with Westinghouse. The contractor was at loggerheads with the owner. But I don't think that's a surprise to anybody.
And it never occurred to you to advise your clients that they might ought to cut their losses and run?
That's true. It never occurred to me.
Never occurred to you?
No, sir.
And Vogel still hasn't been completed, and they're, what, $30 billion and counting?
Yeah, they're going forward.
You think that project will ever be completed?
I think it will be completed, but there's litigation over there as well over the continuation, which suggests that there was no good answer in the face of the dollars.
Thank you, sir.
Okay. Thank you, Commissioner. Commissioners, any other? Mr. Balls or any redirect?
Mr. Chairman, on behalf of SC&G, we want to express our sincere appreciation to the Commission for staying late and allowing us to complete Mr. Winnick's testimony today. I have no redirect.
Okay.
And if the Commission would permit, I'd like to also say that. I do appreciate the courtesy of taking me first thing this morning. That means a lot, and enabling me to finish today. That also means a lot.
Thank you. Okay, well then you can step down and you're excused.
Thank you, sir.
Okay, one thing I want to sort of flesh out for tomorrow. I know we've got some date certain witnesses coming tomorrow, but we still got Dr. Lynch and Mr. Raftery hanging in the balance, and I sort of need to know just for a plan on when we're going to get back to them or how we need to approach that.
Well, Mr. Chairman, the Dominion witnesses, they are date certain. So if you wouldn't mind, let me just have a chat with the co-applicant this evening and see how they want to handle things. But
Well, we've got at least one person who is going to be involved in the cross of Dr. Lynch, and that's from out of town, that's going to needs to go if we're not going to have them here, or if it's going to stay if there's potential. And I don't want them hanging in the wind here.
Completely understand, and we certainly want to accommodate everybody's schedule with that. So if it would be permissible by the chair, I will consult with Dominion this evening. We can send an email to David Butler this evening and let him know what the plan will be and go from there. Would that be acceptable?
Mr. Witt.
Mr. Chairman, it's my co-counsel that has this problem. He misunderstood the colloquy between the chairman and Mr. Burgess last night, so he drove up from Raleigh today to complete the cross, and he needs to know whether he needs to get a motel room for tonight or what. If there's some way they can consult now and let us know. So he doesn't know whether to go back to Raleigh or to stay overnight.
Are y'all going to talk right very soon?
I will get on the phone with them immediately after I exit this room. And
okay, if we can we do that and have Mr. Witt hang in here and y'all tell him that this evening and let Mr. Butler know tonight?
Absolutely, Mr. Chairman, we'll absolutely do that.
Okay. Good.
Mr. Chairman,
yes, sir.
If Mr. Butler could then just circulate that so that other parties will know who's up next, please, that would help.
Who's on first? Okay. Anything else? All right. My granddaughter's birthday is not until Saturday, so I'm going to give everybody a pass on that. But I was going to still go see my son-in-law's dress rehearsal of One Flew Over the Cuckoo's Nest, but what's the point? Okay, so we'll meet again tomorrow.